Good morning, everyone. Myself, Dr. Yogita Gupta. I am Assistant Professor in Symbiosis Center of Distance Learning. I welcome our guest, Dr. Swapnil Bhurat, and Sir has filed several patents, industrial design, copyrights, and trademarks, particularly for industries and academic purpose. Sir has successfully led various funded research projects, including the development of pre-mixed charge, compression integration engineering, engineer technology, and fuel vaporize innovations. Sir has also contributed to sustainable automotive technologies and biofuel research, which has received international recognition. I request Sir to provide us valuable insights on the basis of intellectual property rights and its importance for innovators and entrepreneurs. Over to you, sir.
Sure. Thank you very much, Dr. Yogita. Good morning, everyone. So let me just share the screen.
I will give you the host.
Yeah, host rights.
So you're a host now. You can share your PPT and start the session.
That's true. Yeah. So is my screen is visible to everyone? Is it visible? Yeah. Yes, right. All right. Thanks, Neha. So good morning, everyone. Again, let me just introduce myself in short. I'm Dr. Swapnil. I'm working with DY Patil International University as a associate professor and head of department for the School of Engineering. Apart from that, I am Indian patent agent, and I'm practicing this patenting and IP since last 4 to 5 years. I have filed many patents on my name, and as well as I'm filing patent for the innovators like you people, right? So both way I can understand the pain, the requirement, what is exactly needed for filing the patent, and from filing till the grant, that whole journey. I'm taking the different industry people, I'm taking different academicians, students, innovators, entrepreneurs, right? Whosoever is coming across. So we are trying to take them till the last point of this journey, till the grant of the patent or registration of the patent. Now, in today's session, as the theme, what we have decided is about to make you aware about the basics of intellectual property rights and its importance to the innovators and the entrepreneurs. So, looking forward from the basics IP, first one in the first half, we'll try to take the introduction to the different IPs. Then I will take you through the details of the intellectual property rights in the coming half. And of course, while discussing these basics of IPs, we will also try to understand why it is important for the innovators, to the entrepreneurs, or to the upcoming buddy industry. So I will take you through that whole journey during the session. So basic thing when we are discussing about the IPs. So very first thing we need to understand why IP is needed. That is first thing, why IP is needed and when IP is needed. So these two important things are there, why IP is needed and when IP is needed. So we need to understand why IP and when IP. So if you are going to look into the different steps of product manufacturing, there are several steps involved in it. So if I'm going to say that I want to develop a single product, so for that product, what do I need to do? I need to design the concept of that product. So I'm going to call it as a conceptualization. Then you're going to develop it, test it, validate it, and then you're going to launch it into the market. But while developing the product, you also need to make sure that you're going to reserve your rights. You're going to protect your rights through the different intellectual property protection. Once after these two stages are over, then you are going forward for the whole mass manufacturing process in the last 4 steps, wherein you are going to procure the material, then you are going to adopt the different manufacturing processes, and then supply chain, logistic, and marketing and sales are coming into picture. But these first 2 steps are very crucial when we are talking about the product development and product manufacturing. If you missed something in product development, then your all remaining 4 steps will always going to affect, will always going to hamper, because of you haven't put your 100% in the first 2 steps. So we are saying it usually like good beginning is the half work done. So that is what your beginning must be good, so that you will not be in danger in upcoming span of your product life. So these 2 steps are very important. Now, why then these IPs? What are these IPs for? We must know that the intellectual property rights are protecting an individual or company's investment in the development of the specific invention. We will discuss all these things in detail. Secondly, we are making sure that nobody but the IP holder can benefit from the invention. So when I'm talking about the industry, so usually industries are having number of employees working in it. Those employees are developing some products, some invention. But because these employees are working for that industry, these employees are developing that product. So though they have developed the product, but it will always, that IP will always go under the name of that industry. So when I'm saying IPs will be going into the name of industry, though they have developed by the inventors or the employees of the company, because those employees are getting salaries. So companies are expecting them to develop this product for that company. So industry will be owner of that IP. Usually it happens. So that employee may going to leave that company any moment. And if that IP is in the name of that inventor, then that industry will get in danger once after that employee will going to leave that company. So that is why IPs, who is owner, that is most important. That is most important. Third one is sharing information about an invention with the public. Now it means what? The once I have protected my IPs, once I have protected my intellectual property rights, then I can easily share it with the public domain. It may be for the branding of the product. It may be to get some expertise from the expert, right? Because during the invention development, you may need some expertise of the people, of the experts, right? So that time you need to disclose it to that expert that this is what we are developing. But if you directly disclose it to the expert, he may going to have a similar kind of product at his site. To avoid these kind of things, we are filing IPs, we are getting it protected first. Once it's get protected, then we are going to share, we can easily share it with the public or the experts or whosoever. So that is why protection is must. Secondly, lastly, if you are going to see, keeping an invention secret from the competitor. Now, sometimes IPs are giving you such a kind of facilities wherein you can keep your IPs at a secret level. We are calling it as a trade secret. We are calling it as a trade secret. So see how you may going to find the point number 3 and point number 4 controversial. In the point 3, I'm talking about disclosing it to the public, right? It may be then to the competitor, it may be then to the common man, it may be to the experts, anyone. And in the 4th point, I'm talking about the keeping secret. So both these facilities are given in the intellectual property rights. If you want, you may open up. If you want, you may keep a secret. So that is what the good thing about IPRs. It gives you that kind of facility which you want with your product, right? We'll take the examples during this session and we'll try to understand how we can keep the secret and how we can open it up. So what I was talking about, that when your product should be protected. Now here I have shown two different processes. I'm calling this one as a first, this one as a second. So in the first case, if you're going to see in the stage of product development, I'm doing the conceptualization of the product first. Once my concept is developed, then I'm going to design it technically through the drawings, through the models. So design and engineering will come into the second step. Once the design and engineering is done, then we are looking forward for the prototyping of that product. And here we are going to develop the proof of concept of the product. That yes, now we have developed certain prototype. Once that prototype is developed, then we are moving ahead for testing and validation of that product, whether it is feasible at the market conditions or not. And then we are going to protect the product through the IP protection, intellectual property rights. Now, in the second step, when I'm going to develop a product design and development, I'm conceptualization of the product will be in the first step. In the second step, there will be design and engineering. Now here, I'm quite sure now my product is quite good, quite enough to be launched. I have developed the concept. I have developed the design. Now, without waiting for prototyping and validation, I may go for directly IP protection of the product. And most of the industries are protecting their IPs at the third stage only. Once they have developed the concept, they have designed it primarily, they are going to protect it at the third step only. Rather than waiting for prototyping and testing and validation, they are going to protect their IPs first. It may be provisionally they are going to protect. Or if their concept is fully developed, then they are going to protect it completely. We will discuss these 2 points as well in coming slides. So after that, they start building up the prototype and then they are doing the testing and validation. Why this is important? Because most of company, when I'm saying they're protecting their products at the third stage only, it is just because they don't want to take that risk of time. Here I'm spending extra time in creating prototype. and in the testing and development, right? So in that stage, in the second step, if I'm going to protect my IPs, if I'm going to protect my IPs, then there I'm going to save my time, and I'm going to protect it at the early stage of my product development. So these things are very important when you are going to develop the product. So I always recommend the inventors to protect your IPs in the third stage only, rather than waiting to create your prototype and testing. So here again, I want to tell you one thing, that for protecting the intellectual property right, it doesn't require prototype, it doesn't require testing and validation. If you are sure enough that yes, it's going to work out in the way what I have thought, you please go ahead for protecting your IPs. In very rare cases, IP office, the intellectual property rights office, Indian Patent Office, may going to ask you to demonstrate your product. And when they're asking you, usually they're asking you when they are thinking that it may be fictitious, or it may be very means how come someone can achieve this much efficiency, when they are feeling some little doubt, that time usually they are requesting you to demonstrate the prototype or to demonstrate the product, to show the product. Otherwise, usually they won't ask, right? So when I'm talking again the IPs, then what are these IPs are? These IPs are nothing but the assets. These are nothing but the intangible assets. So we have usually two types of assets. One is tangible assets, another one is intangible assets. So when I'm talking about tangible assets, so all your physical form of assets are comes into the tangible assets, like your land, your property, your house, the equipment, machineries which you have purchased. These all comes under tangible assets. However, when I'm going to talk about intangible assets, so that time your all IPs, like your patents, your copyrights, trademarks, brand names, goodwill, softwares which you have protected through the copyright, customer list, these are all intangible assets. You cannot have a physical form of it, but you have the uh, uh, more than that physical form assets with you, because it may have a good value. Like usually I'm giving example that Apple is having more intangible assets than its tangible assets, because they have thousands of patents filed under the name of Apple. And those all patents are technology ready. Those are all ready to launch in market. So if they want, they can sell that patent to the other parties, other industrialists. So they can earn huge money out of it. But usually they don't sell. Why? Because they know whichever product they have developed, that will going to give you good cost compared to if I'm going to sell that product to some of the industry. So that is why they usually won't sell their patents, but their patents are having very huge value. So that is why we are calling Apple is a billion-dollar companies all the time. Though they are physically their asset is not coming into the picture, but if you are going to count their intangible assets value, it is huge. So what are these different types of IPRs? What are the different types of IPs available through which you can protect your IPs, your ideas, your invention, right? So very first is coming patents. So patent may be your utility patent. So patents may be utility patent, or it may be process patent. Process patent. Now, when I'm saying utility and process, it means take a simple example. I'm working, say, in pharma industry, and we are developing one formula to prepare some medicine. So that process which I have followed to develop that formula, to develop that medicine, it is all coming under the process patent. And when I'm saying utility patent, take a example of, say, vehicle. I have designed new type of steering system. So when I'm saying I have designed new type of steering system and it has certain functionality, it has certain mechanism, right? So that time I can protect that mechanism which has certain functionality, which has certain industrial applicability, which has certain inventive steps involved in it, which is differ than the existing steering mechanism available in the market. So that mechanism I can protect through the utility patent. Now, copyrights. Copyrights have many different types. We will discuss it. Industrial design. Industrial design. So here what I'm talking about, here I'm going to talk about the aesthetic of the product, appearance in more easiest language, appearance of the product. So when I'm saying appearance, it means how does it look? What is its shape? So in industrial design, it has nothing to do with the functionality of the product, but it has to do with the how does it look? What is the shape of body? The car body, right? The different structures body you're seeing in a market, which you can see it with your open eyes. Those are all industrial design. But when I'm talking about functionality, its performance, I always talk about the utility patent or process patent, right? So let us take, say, for example, tablet. I have made a tablet and I have process patented that tablet. But to sell that tablet in market, that medicine, that tablet, I need to cover that in the covering, right? So different types of coverings you are seeing to keep those tablets safely. So the covering, the external appearance, the packaging which I'm going to design, that I can protect it through the industrial design. But the tablet which I have made with some process, certain formula, that I can process patent. So this is the biggest difference between industrial design and the patents. In market, in layman language, many people are calling industrial design as a design patent. Design patent, right? Because in some of the developed countries, they have given industrial design as a name of design patent only in their Patent Act. But in Indian Patent Act 1970, we have industrial design as a name of that design patent, right? Patents are get granted. Patents are get granted. Designs are get registered. So there is no grant word in the industrial design. There is a registered word. Similarly, in copyright, it get registered. It won't get grant. It get registered, right? You have applied for the copyright. It get registered. Similarly, trademark. Trademark, it means you are protecting your, say, brand name, your what you say, any slogan or any taglines. So you are protecting your business name or everything through the copyright. Now here you can see trademark. On some product you may see TM, and on some product you may going to see the registered, right? Say for example, Bisleri bottle is there. So Bisleri bottle is having, say, R written just ahead of its name. It is registered. And if it is written TM, so it is under the process of registration. They have applied for the registration process, but it hasn't get accepted yet. So it is under process. So till that time they can use TM. Then is coming geographical indication. Geographical indication means now certain places are having their what you say their speciality, right? So whichever specialty they have, they can protect that specialty. Like say, for example, Darjeeling tea. So it's a specialty of Darjeeling, right? So that specific region has certain specialty, and that quality of that product is available there only. Many people are selling Darjeeling tea in different zone under the name of Darjeeling. It is actually infringement. They're not doing right thing. They're doing the duplicacy, which is not ethical. Trade secret. Trade secret, it means what? Trade secret means I have developed certain process, certain recipe, but I don't want to share it with anyone. I want to keep it as a secret. So that time, the inventor or the owner of that product may file the IP protection under the trade secret. So the famous example for these trade secrets are like your Coca-Cola recipe. They haven't disclosed it to anyone. Then the Legos, which is the famous company, Legos, when they have manufactured the blocks, the games blocks, so that time they developed it with some plastic, and that plastic is recyclable. So they kept that process, that how plastic can be recyclable, which is just a question to the many people. So they kept that recipe, they kept that process as a trade secret, and they didn't disclose it to anyone. So this is how companies can, or inventors can, protect their ideas through the trade secret. And it has no life. It has no life. Like say, for patents, you have 20 years life, but that too you need to renew it every after third year. You need to renew it every year. When you are filing the patent for the first time, so during the first time application only, you are paying the fees of 3 years. Third year onwards, every year you need to renew your patent if you want to uh, uh, if you want to keep your patent's life alive, and that you can protect till 20th years. Copyrights, it may have a life of 60 years, or maybe sometimes till the death of the person, or of the owner, right? But it has the largest life in all the IPs. Industrial design has the life of 15 years, but again, up to 10 years, it is by default, it is having a life. After 10 years, if you want to keep continue with the same design, you need to pay annual fee. But up to 10 years, while filing only, you are paying that fee by default. Trademark, every year you need to renew. Geographical indication and trade secret. These are geographical indication you cannot apply individually. It has to come from that society, from that region. Specifically, what I have given the example, say Darjeeling tea. So it has to come from that community. They can apply for that GI. And if they get granted, it will be for that society for the lifetime. Similarly, trade secret. It is up to the owner how long they want to keep it as a trade secret. So it has no life. So these are the different types of IPs one should know, and one should understand that which IP I have to go for protecting my different, what you say, different inventions or innovations, right? Am I audible? Am I audible?
Sir.
Uh, just a minute.
Yes, sir. Loud and clear.
Loud and clear, right? Any doubt till this? If you can have 1 or 2 minute question, I would be happy to answer. Any question till this? Yes, please. No questions? Okay, let us move ahead. Now, moving ahead, which IP I should go for? That is again a main question, important question to all the participants, all the inventors, that which IP I should go for protecting my ideas, for protecting my innovations. So very first, though I have cleared you in the previous slide only, but very first, say for example, patents. I told you, if your product is having any industrial applicability, if it is having any inventive steps involved in it, if it is having some performance improvement in it, so that time you can go for patents. So make sure it must have novelty, some uniqueness, some non-obviousness must be there in order to get it patented. Copyright. Now, various types are there for the copyrights. It may be literary copyright, it may be cinematography, it may be artistic. You have drawn something which which is your creation. You can protect it. If it may be photography, right? So different types of copyrights are there available. When I have written some blogs, for example, and I want to get it copyright, yes, you can get it. You can register that copyright under your name, and then you can publish that blog. Many people are doing that thing so that stealing can be reduced. They cannot steal it very easily. So if you have said that it is copyrighted, that's it. Then if somebody can steal that, you can sue them, or you can ask them for the compensation, or you can simply ask them to remove that from their site or from their uh, product, whichever. So copyrights are having different types. Industrial design, whenever you want to protect any appearance, any shape of the product, that time you should go for industrial design. Here, you're not talking about how that product is going to perform, how that product looks from inside. No, you are going to protect your IPs through the industrial design only for the outer shape of that body, outer shape of that product, appearance. Trademarks, again, brand name and your goodwill, you're going to protect. Geographical indication, individual cannot protect it. It should be from that community of that specific region. And trade secret, again, it's up to the owner of that process or of that product, whether to keep it secret from everybody or to disclose it through the patent to the public. So these are the different IPs one should know, and one should understand which IP I should go for which purpose. Now, let us say patents. So when I'm talking about the patents, you just see here. Now, let us example, say the Jackson shoe. It was a Jackson shoe. It was patented. So what is novelty in it? It is similar kind of shoe. But the difference is that the slot which he has given under the shoe, right? This slot you can see, which is going to help you to fix under that nail, and because of which he can able to do his best move during the dance step. And it was happening because of that shoe design, that shoe mechanism what he has made, and because of that mechanism it was able to lie down or to bend down without bending actually into the back, in your back. So that mechanism was a patented technology of a Jackson. So we are calling it as a Jackson shoe. Safety pin. If you're going to see the safety pin, which is the simplest possible patent, which gives a huge earning to the patent owner. The story of this safety pin is very simple story was there. One of the inventor was there. He developed, he took one wire. If you're going to unwound this safety pin is a single wire which he has bent down in different shape. So this bottom shape is a spring. It acted like as a spring. And the upper one is the head of the spring. right? So the upper one is also made from the same wire. Because of high heating hammer, we can get that shape. And nowadays, now different types of safety pins are started coming in market. But in the start, when he has made that safety pin only with the single wire. So it was this head of the safety pin was hammered and it got flattened, and because of which it got that shape. So it was made from the single wire. So this patent, when he developed, he sold that patent, the inventor, the owner of the patent, he sold that patent at a very cheaper cost to the industry person. And later on, that industry person got billionaire because of the safety pin production. Nowadays, you can see this safety pin in every house, specifically when we're talking about the woman. Every woman is using these safety pins in huge quantity. So that is the simplicity of that patent, and which gave a huge amount of money to the owner of that patent later when he purchased it from the inventor. And similarly, the paste, the tube, the mechanism, what they have designed for that paste to come on the brush and all. So it was all designed and it was all patented. That process was get patented. And these are the different examples we can understand from the patenting. Similarly, when I'm talking about the design, so that time, I'm sorry. Yeah. So when I'm talking about the industrial design, so that time you can see these are the different shapes, like this purse is there, uh, uh, this iron is there, this wallet, different shapes of wallet you're seeing in market, watches, right? Slipper, chappal. In fact, this pencil or pen holder, right? So these are of different shapes and these are available in market. All of this brush, you can see the design of the brush, the external appearance of the brush, it's all get protected under the industrial design. Now you may see the different types of bottles available in the market. Let us take example, say Bisleri bottle, say Kinley, and say Ballet. So all these bottles are having the different shape and nobody can steal each other's shape. Why? Because it is protected under the industrial design. It is protected under industrial design. You may search it on IP India site. You will get to know whether it is protected or not. It is protected. So that is what we need to understand, that industrial design is giving you, or it coming in picture when many competitors are there in the market, but still you have to keep your identity. Like water bottle sellers are, many water bottle sellers are available in market, but still everybody has their own identity through some or other way. Like Kinley, when they are talking about, I always get few things just in front of my eye, is that their blue color, the shape of bottle. Similarly, Bisleri, when they are talking, that green color is comes into uh, my imagination, and their shape of bottle. Similarly, Ballet, blue color is coming into picture, and then their shape of bottle. So likewise, they have protected their things, right? So industrial design is very easy to protect, but it gives you a very good right to exist in the market. So to file the industrial design application in India, you need to fill the form, application form. You need to give the design drawings or the photographs available of the actual product. You need to give a brief description of the design, that what is the purpose of this design, why you have made this design. Only that single paragraph you required. What are you exactly going to claim? So you need to define the class of that design. There are different class under the Design Patent Act. So from there, you need to fix the class. You need to pay the fees. If you are going through any patent agent, then you need to give a power of authority to that patent agent. Power of authority means you are giving a right to that patent agent to file your patent application on your behalf. So he is your assignee. He can be your assignee. So you are assigning the rights of filing your design patent or patent on their behalf. They don't know the process of filing. That is why patent agents are made. So that is why you need to give power of authority. And prior art search if required, but it is not compulsory again. You can directly file it, but it is must. You can save your money if you are going to do a prior art search properly. Again, this is done by the patent agent. You are doing the prior art search, then you are going to get a fair idea whether your product should go for patent, should go for design or not, whether it is available in market or not. So that basic search is required before you go for patenting or filing your application. So this is just example I have given for the industrial design. This was my product only. So this is a container what I have designed. And when I was in Dehradun, so there we were using there we were seeing the people were taking the water from downside hill to upside hill. And they were taking that water in the container, either by walk or it might be on two-wheeler. So we have seen that they were struggling with that problem. And we observed that they're keeping some cloth over the head, and over that cloth they are going to keep that container so that it may not going to disturb their head with the hard surface of the container. So they were keeping some cushioning in the form of cloth. So we understood that. Secondly, when they were taking it on the two-wheeler, they were tying it up on the two-wheeler, and then they were taking it over the hill. So we observed that problem and we have designed one solution. So we take a simple container which is already available in market, and we made two changes in that. One is that we have given a dome shape and it was cushioned. So now when they will take this container over the head, they don't need to take that extra cloth what they were taking. So this cushion will going to give them a smooth effect, soft effect, and it will not going to disturb them. It will not going to reduce their stamina while taking that container from down to uphill. And secondly, we have given some grooves on the container. So you can see the grooves. So these grooves were accommodating that thread, that rope, which they are usually using to tie it to the two-wheeler. Right? So these two slots we have given. Otherwise, we didn't do any changes. And we got that industrial design got granted, got registered under the IP India site. Now, what we need to give? Here, if this container is there, I need to give its different views to the patent agent so that he can file and he can claim that this is how it looks. So they can file it to the government of India on your behalf. So we need to give, say, front view, top view. How does it look from top? Left side view, right side view, left, right, and perspective views. Right? Perspective views means nothing but your isometric views, you can say. So this is isometric view. In isometric as well, you have left isometric, right isometric, likewise. So these different shapes, these different views we need to give when we are going to protect our shape of the product, because you need to make them very much clear. You need to make Government of India, the IP India, very much clear that, see, this is my product and this is how it looks like. You please give us the registration. So they are going through it. They will be doing search. If they found that, yes, your product is okay to register, they are registering your product. and then you can treat yourself as owner of the product. Okay, one more good thing about the patenting is that when you're applying for the patent or when you are applying for the industrial design, from the day when you applied and you got the application number, you can treat yourself as a owner of the patent, whether it is get granted or not yet. Because you have reserved the rights, now you can treat yourself as a owner. Later on it gets granted, okay, you can keep continue your product, what you say, you can keep continue your product production. So that is what a good thing you can do. You are protecting your priority by filing the application to the government of India through the IP India office, right? You can also file this patent internationally. Like when I'm saying internationally, it means, uh, let me just give you some brief idea about it. Like when I'm saying I have filed a product in India, I have filed a patent in India. So when I'm saying filed in India, then you have reserved your rights in that specific country only. It doesn't mean that now your product is worldwide protected. No. Now say, for example, if you want to sell your product in New Zealand and you haven't protected that product in New Zealand through the PCT Act or through the PCT convention, so you are not owner of that product in New Zealand. If you want to sell your product, if you want to protect your product in New Zealand as well, you need to file application for patent in New Zealand because their patent law is different. So you need to apply there as well for protecting your product. So just giving you an example of Apple again. So when Apple is launching any product in several countries, wherever they want to, that time they are protecting their product in those hundreds of countries, 140, 150 countries all together, so that their rights will be saved and nobody can steal their product. That is why we cannot see a copy of different mobile phones available of different brand names, similar kind of brand names product we cannot see in market. Why? Because it is unethical then. So all these industry manufacturers, what they are doing now, if they want to protect it internationally through PCT, they can make an application and they can simply select the country in which they want to apply. They don't need to apply separately in all the international countries. Through one application, they can protect it in all the international environment, right? But they need to pay that fees separately. But application will be one. So that is why it is needed to protect your product in the same or in the other countries wherever you want to sell your product. So as I told you, importance of design is that when you're having a huge competition in market with the similar kind of prices, so that time you can project your product, you can sell your product at a good level just through the best design, just through the best appearance. So appearance makes a big difference in your sale. Appearance makes a big difference in the market value, right? So that is why designs giving you a huge importance while protecting your product and while selling your product in the market. Copyrights. So as I told you, different types of copyrights are available. So you can protect your book chapters, you can protect your single page write-up. If you want, if you think that this is the content which I must protect, please go ahead for protecting your copyrights. Very cheaper to protect, very simple to protect. Dramatic work, all these dramatic works, their scripts, they are protecting first before they're going to disclose it to the actor and to the public, whoever. Sound recording, yes, you can protect it. Artistic, musical work, cinematography, all these things, software, all these things you are getting their copyrights protection. So any film before it get launched in public, in market, it's all get protected through the copyright office. trademarks. So you can see here now, McDonald, you can see here they have written the registered, right? Amul, the taste of India. This whole tagline and that product name, it's all get protected. L'Oreal, in fact, this apostrophe, that also this sorry, not apostrophe, this mark what they have given, L'Oreal. So whole word is get protected. All small things are getting protected, right? So like Amazon, they're having a simple sign like this, right? A to Z. So it's get protected under the trademark, right? So likewise, the different brand names are protecting their tagline, their names through the trademarks. Trade secrets. Trade secrets are, as I told you, if you want to protect your formula, your practices, best practices which you are adopting while working, if you want to protect it. You keep it as a secret, a recipe of your product, right? Like say Everest, Pav Bhaji Everest masala. It is trade secret. Nobody knows that. That is why we are not getting a similar kind of taste of Everest Pav Bhaji masala when we are purchasing the other one, say Suhana Pav Bhaji masala. So you're not getting the same taste as that of the Everest Pav Bhaji. Suhana is having different taste. Everest is having different taste. They have protected their recipes. A process, a design, an instrument, right? A pattern or compilation of formation. Anything you can keep it secret, which you think that this is the USP of my business, this is the unique selling price of my business, please keep it trade secret. Don't disclose it to the public. If you're thinking, if I'm going to disclose it in a public, and then I may be in loss in short time, then please don't disclose it. Keep it as a trade secret. Now, Coca-Cola recipe, it known to only 2 or 3 people in that company. And whenever they want to produce the what you say, they have kept that trade secret room specifically from where that specific formulas recipe is coming, and then it's getting mixed to the water or whatever they are making, and then Coca-Cola is made. So that they kept is as a trade secret, and it never get disclosed anywhere. Geographical indication. Now, when we are talking about geographical indication, you see like Kashmir shawls, right, are famous. So you can see there uh, uh, the shawls are the unique uh, thing what you are specifically getting in Kashmir only, right? Similarly, if you are going to see in Maharashtra, if we have something, then Nashik Valley wine. It is Mahabaleshwar strawberry. It is GI. That specific strawberry you're not going to get. When I was in Dehradun, I was also getting strawberry in Dehradun. But the specific category of strawberry which you are getting in Mahabaleshwar, that you are not getting it there. But what happens is many people, they're doing a wrong business. They're selling that wrong strawberry under the name of Mahabaleshwar strawberry. So they're following it unethical practice. So to reduce this kind of practices, that is why the communities are taking the geographical indications and they're protecting their products. They're keeping the beauty of their product as it is. So these are the different examples what I have shown here. Like in Madhya Pradesh, leather toys of Indore. It's a unique quality of Indore to produce the leather toys. So they have given that GI tag to the Madhya Pradesh, right? So likewise, these all things we need to Puneri Pagdi. Puneri Pagdi. So this is again one geographical indication what we have protected, right? Now recently in Uttarakhand at some Pahadi area, they have got the GI protected for some specific dal, right? जैसे कि what you say अरहर का dal hai. So likewise, some kind of dal they have protected under the name of GI. So these are the specific, and it's going on increasing day by day because the awareness is increasing now, and because of which you started protecting your unique quality of your specific region, right? Bikaneri bhuja. We know the Bikaneri save is always popular in market. So Rajasthan has that unique identity, Bikaneri bhujia, right? So likewise, you are having different GI protection. So there are three key requirements to safeguard your innovation and creativity. So when I'm talking about the patents, what needs to understand when I'm going to protect any invention in the patenting? So three things it must have. It must be novel, unique. It must have a non-obviousness. It should not feel like, oh, ये तो कभी भी हो सकता है. No, it must have non-obviousness feature, and it must have certain utility, functionality, industrial applicability, right? So these three important things are required when you are going to protect your patent. Copyrights. So when you are going to protect your copyrights, it must be original. It should not be copied from somewhere else. Fixation. It must have some creative expression. You can register it under the copyright. Trademarks. It must be non-deceptive, must be used in commerce. Usually trademarks are getting protected in the commerce industry. And industrial design, again, the same kind of feature we must have like patent. Only one extra thing, it has nothing to do with the utility. It has to do with the aesthetic appeal of the product. Aesthetic appeal of the product. So when I'm taking a vehicle as an example, how that vehicle is performing, industrial design doesn't care that. How that vehicle looks like, that shape you can protect it to the industrial. So for the single product, you can have a different IPs protection. So if you are seeing here, patent, copyright, trademark, industrial design, and GI, if you are going to see this, so patent is the one which is going to talk about the novelty, going to talk about the industrial applicability, likewise. So similarly, these different features. So you just understand here, GI, all these things I have explained you. In case of GI, geographical indication, you see here, the reputation. Darjeeling tea is a reputation of that specific geographical region. So you cannot steal that reputation. You may going to sell that product in Maharashtra, but you should sell it under the name of Darjeeling tea, and that too, that product must be originally acquired from the Darjeeling. You should not make a fake copy of any tea product and sell it under the name of Darjeeling. If you are going to caught in that practice, there will means we are calling it as a malpractices. You will be behind the prison, or you may need to pay a huge penalty behind it because you have damage to their business. You have damage to their reputation. So that is why geographical indications are at most important while selling the product. Let us see some examples now. Say patent. So patent is like bottle of the Coca-Cola, the material what they have used to manufacture this bottle, they have protected under the patent because they have newly developed the composed material of that bottle with which they have manufactured that bottle. That material they have protected. How they have made that material, the process of material making, they have protected. They have protected the Coca-Cola name under the trademark. They have protected the shape of Coca-Cola bottle under the design, industrial design. And they have kept the recipe of the Coca-Cola making. They kept it trade secret. So you can see, I wanted to protect my product. I have used the 4 different intellectual property rights through which I have protected it, through the patent, through the trademark, through the design, and through the trade secret. Let us take some more examples. Say Apple. So here Apple, they have the patent, many patents are there. But let us take one example. They have protected their camera processor, very fast, with best quality. They have protected it. They have protected their name through Apple, through the trademark logo. They have protected the appearance of the phone through the design rights. And the manufacturing process of that Apple product, they have kept it as a trade secret. So through the 4 different IPs, they have protected their product and they are quite safe now. Similarly, I gave you example of Lego. I told you they kept the material which they have used. It is a recycled material. So they kept it as a patent. The postic formulation, what they have used in this one, they kept it as a trade secret. And the shape of that bricks, which they have made it in the form of different blocks of toys, they kept it as a design right. Now, we need to understand that only by protecting your product through patent, it's not sufficient. When you are thinking yourself going to be a upcoming manufacturer, please do not try to save your money by not protecting your things at the right time. If you will protect it, it will always going to give you a good pay. Because if somebody going to steal your product, you have your priority application number with you. You can send infringement notice and you can ask them to stop manufacturing it. Apart from that, you can ask them to pay the compensation because of which they have made a loss to your business. You can ask for all those things. And when you are protecting your things with some priority numbers received from the government of India, you are completely at a safe level. So we need to understand these things when we are going to put ourselves into a business or into a manufacturing products. Like it will gives you a different kind of protection. Say this Gillette product. So its design is the razor, unique, 4 steps, 5 steps, 3 steps. The razor cartridge is a unique design what they have made, right? Previously, razors were coming in only single time use. Then whole this remaining body of the razor was of unused. Once the razor life is over, it's gone. Gillette brought that refilling of razor into market and they again took the boom in the market. Then again, blade geometry, they patent it because it has certain functionality, right? Then trade secret, the razor coating which they have made because of which you are getting a smooth shave. That razor coating, they kept it as a trade secret, right? So these are certain examples we need to understand from the product's point of view, right? So these are certain more examples I have given. So say this is uh, one product, cucumber, you may say. So it's a different variety of product. Now what they have done, they have kept the parent lines, they kept it. How did it appear on that? It is appear because of certain process what they have made while planting the tree. So these parent lines, they have kept it as a trade secret. The trademark, the name for disease resistance, what they have protected. Patented is because it is disease resistance. So there are certain parameters involved in this type of vegetable. So they have patented it. Now we need to understand there are two things. One thing is that few things are already exist in the nature. Few things are already exist in the nature. And if somebody has discovered those unknown things, it is already available in nature, but nobody knew that. Nobody knew that the gravitational law, right, which was given by the Newton, right? But he discovered it. It was available, but he discovered it. If it is that kind of invention, it is not going to be patented. Why? Because it is already available in nature. It was already available in the nature, but he has simply discovered it, that things are coming towards Earth because of the gravity. So gravity he found. It doesn't mean he has invented. It was already there. He just found it. You cannot patent it. So mere discovery of any unknown things which was already available in the nature, you cannot protect it through the patent. But now, in case of, say, this product, which is, say, agricultural product is there. So here they have done certain processes, they have made certain breed. So in some other countries, you can protect this kind of breeds through the patenting, through the different rights. In India, we are very specific in case of agricultural development because we are agro-based country. So in many cases, we cannot protect the any new product developed in the agricultural based just through the patenting process. Why? Because we are agro-based countries. Our main business is from agricultural. So our population is huge. So country is not allowing you to protect all these things. But yes, of course, there are certain things through which you can protect your ideas in agricultural field as well in India. In Patent Act, Section 3, Section 4 is always talking about things which cannot be patented. The Section 3, Section 4, Section 5 are talking about the inventions that cannot be patented. So under that, this just mere discovery of any product, you cannot protect it. Or there are some horticultural and agricultural based conditions are also given, which you cannot protect it. So, but in other countries, you may protect it. So that is why I told you, internationally, the patent law is different in the different countries, right? When we have made a Patent Act 1970, we followed it, the British Patent Act, because we were British ruled. We were following the British patent law. Now, after that, many amendments came into the act, which was required at the country level. And we started protecting it through the different ways. And we started making some amendments, right, in the Patent Act as per the country need. So these are again certain different examples you can understand. Trade secret, design patent, patent boost technology, and 3 strips, right? So these are the trademark of that specific company. LinkedIn. Now this is interesting. That is why I have shown this. So if you're going to see the algorithm of the LinkedIn, they kept it as a trade secret. They didn't disclose it to anyone. Otherwise, anybody can copy it because nowadays it's very easily available. So they kept it trade secret. Similarly, recommendation. Now, if you're going to use the LinkedIn, you are getting some same interest people recommendation at your profile, right? So that network recommendation techniques which LinkedIn has developed, they have patented it. Similarly, they have now in case of design patent, now they have protected this LinkedIn name under the design registration. Under the design registration, right? They have protected it. So it's graphical user interface. So now when you are protecting this kind of things, you do not need to give number of views, which I have shown in the previous slides, like top, front, side, bottom. No, you simply need to give a single image which you want to protect it under the industrial design. So it's graphical user interface you are going to protect. that is allowed, and that can be get registered under the industrial design. And the name LinkedIn is again trademark. So these are certain example which we should understand from the basics of patenting. May I please have some questions now? Am I audible?
Yes, sir.
Yeah. So any questions, I would be happy to answer. Please ask some questions. Yes, please. Any questions?
Hello, sir.
Yes.
Myself, Dr. Kutima.
Yeah.
Am I audible to you?
Yes, sir.
Actually, I worked in Africa.
Mhm.
Some of the projects, actually, basically, I'm from the civil engineering background. We done some of the research works, which is not still now it's protected, but we can be doing Indian patent law as per that. It's possible
Yes.
because we done the research in the Africa.
Yeah.
Some of them utility oriented, some of them some design concept.
Mhm. You can protect the application in India. Recently, I have filed one application of one of the professor from South
Okay,
India. So they can file the patent in India. Only one thing, they must have
okay,
they must have some Indian address. So in that case, what we are doing, because I am a patent agent, I gave my
okay,
office address to file their,
okay,
and I have filed their patent. So that is the only one important condition they required, that they must have something
okay,
as an address in India. So that address you are always
okay.
assigning the patent agent. So that patent agent address can be used for the communication purpose, not for other else.
Okay, it's not like a complete rights to for that particular person. On behalf of them only, they are going to be filed. So for
Yes,
that
yes,
one
the
only, they
patent
need a.
agent has no rights
Okay,
over that patent at all, not a single percent right.
okay,
Right? It is just like you are fighting one
okay,
case. It is just like you're fighting one case
okay,
in court, and you have appointed a lawyer.
okay.
So
Oh,
patent agents are your lawyer to protect your intangible assets.
yeah, understand, understand. Okay, yeah, and practically some of the that means many of the people are they do, not having the knowledge to file themselves. Even uneducated people also having some innovations also they can file on behalf of. So only I think they made a
Yes,
rule
yes.
like this. I think.
Yeah, that's true. So you don't need to know everything, right? See, because if you are inventor, you don't need to know how to protect it. People are available for that purpose. See, when you want to protect something in your physical form of properties, like house or anything, what are you doing? Are you fighting your case on your own? No, you are simply appointing a lawyer. Similar way, you have a kind of lawyer in the form of patent agent to fight your technical thing, right?
Yes, sir. Yes.
Yeah. Any other question, please?
That's very clear, sir. Thank you. Thank
Yeah.
you.
Any other query, please
Hi,
ask.
sir.
Hello.
Hi, sir. I am Vasant, and thank you for the topic. Very interesting, sir. The way you have explained, and maybe I have a simple question. It's like the certain organization or some companies who adapt the promotion strategies or marketing strategies.
Hmm.
Is that can be protected as well because they have worked out how to promote a product,
Yes.
and later on when it is successful, someone copied it, so they lose the value, right?
Yeah,
So is there any way it can be protected as well?
yeah. So marketing strategies, yes, you can protect it through copyright. You can protect it through trade secret,
Okay.
right? You
So
can.
so there is a limitation. There is a limitation that others can copy the same strategy to promote their products, right?
Yeah, but if you have protected it, you can always have those rights. You can always sue
Mhm.
them.
Okay. So is there any a period of protection or period of this thing?
Yeah.
For
So
example, it's a 1 year protection, or it's going to be a lifelong protection of
no. So
that pattern, or
if you're filing a copyright, I told you in the starting of the session, if you're filing copyright, you're getting 60 years of protection,
okay.
right?
All right.
You're
Okay.
entitled to
Thank you.
20 years. When you're filing patent, you're entitled to get 20 years protection. based on the condition, if you are renewing your patent every year, means you need to pay that several minimum amount of fee to the government of India to keep your patent alive, to keep your copyright alive, right?
Okay. Okay. Clear. Thank
Any
you so much.
All right. Should I move ahead? Yeah. So let us just move ahead. Yeah. So now here, I'm going to tell you the process, the steps which one should follow while filing their patents. While filing their patents. Now, the key steps one should understand while filing the patents are very simple. Say that you have an invention with you, and now you want to protect it. You want to protect it. What will you do? You will simply follow certain steps. Few steps are mandatory, and few steps are at your will, you can adopt or you can reject. So when you have developed certain product, and if you are planning to file the patent for that product, I always recommend to do a patent search through the professionals. Why this patent search is required? Because if you avoid this patent search, sometimes we are thinking why to spend money in patent searching. But if you are not going to spend that minimum amount of patent search to conduct that patent search, then what happens? It may be possible after you file the patent, you may get a clear objection from the patent office that this is already available in the market. This is already available in the market, so it is not patented. So whichever fees you have paid for filing the application, for drafting the application, for publication, for example, it's all gone waste then. So to avoid these kind of things, it is always recommended to have a first step, that is patent search. Now, in the patent search, you get a better clarity, at least 60 to 70%, you get better clarity that whether your product is novel or not, whether your product is available in market or not, similar kind of product is available in market or not. So this idea, once you get it, then you should go for the next step, that is preparing the patent specification. Now, as I told you, you can protect your product at any stage of your development. So if your product has just developed the concept and design, but you don't want to waste time and you want to protect that idea, I always recommend to go for provisional specification. So when you are going to apply for the provisional specification, that time, once after the filing, you will get some application number, say 1, 2, 3, 4. Say this is application number. So this application number is giving you that right that yes, this idea, this concept is yours. Now you take 12 months from the government of India to develop your idea and to file the complete specification under the same application number. Because you have reserved the priority, now you file a complete specification within 12 months. If you fail to file the complete specification of your product within 12 months, then your patent will be abandoned, will be considered maybe withdrawn or abandoned. Right? So you're getting 12 months of time to develop a complete product. The stages which I have shown you, prototype developing, testing, validation, those all things you can do it at your firms, at your source area. Once you are firm, now you file the complete specification. Sir, so you are having a huge scope to protect your idea in the early stages of the development of your product. Now, once you're now, if your product is already ready now, you just want to protect it, you directly go for the complete specification. You directly go for complete specification. Now, once your complete specification is ready, here we are calling it as a drafting, patent drafting, right? Then you should file the application. You should file the patent application. Once your patent is applied, once your patent is filed, then I always recommend to follow 2 steps, which is not mandatory, but if you don't follow it, your patent may get abandoned. So always make a request for publication. You need to fill certain forms and you need to pay certain government fees and request for the publication. Now, what happens? Why I am recommending it to do it? Its fees in India is only 2,500 rupees, government fees. And maybe professional fees, say 1,500 maximum. So if you are paying this 4,000 at this stage, what will happen and what advantage you will get? Now just see, come to the second step again, third step again. So once you have filed the patent, now it has a waiting period of 18 months. It has a waiting period of 18 months. After 18 months, it gets published at the site of Government of India, IP India journal. But if you pay the 2,500 fees for the request for publication, within 30 days, it's get published on the Patent India site. Publication, it doesn't mean granting. Publication, it means now they brought your product in the public domain. They are asking the public to challenge. If you have any challenge, you can take any objection. So once that 30 days period is over, they are publishing it on a journal. So now you don't need to wait for extra 17 months. If you don't pay this 2,500 rupees, then what will happen? You need to wait for 18 months. After 18 months, it get automatically published on the government site. And after that, it will go to examination. Now, examination fee is also there. That is 4,000 government fees. So when you are paying this government 4,000 fees, it means now you are interested to examine your patent. If you don't pay these fees before 36 months, then your patent will be considered as abandoned, that you are not interested to examine your patent. Now, whole further processing of granting and rejection will get stopped there only. And it will not considered as your patent, right? Many people are doing this kind of things as well. So request for examination is filed with 4,000. Now, the moment you filed, within few months or few days, it may go under examination. Once it goes under the examination, your examiner, whoever is appointed by the controller of patent, will going to examine your patent and he may going to give you some examination report in which he may going to take certain objection or he may going to raise some questions, right? Or he may going to suggest few things. Anything may going to happen in the examination report. Now, once you get the examination report, you need to file the response to the examination report. Once the examination report is filed, and if still examiner is not satisfied with your patent or with whatever response you have filed, then he will ask you either for the second examination report. In short term, we are calling examination report as FER, SER. It means that first examination report, second examination report, likewise. If he's still not satisfied with your answers, which you have given, which you have responded, then he may call you for the hearing. So hearing is maybe online or it may be offline. It is up to you as an applicant of the patent. That choice is given to you, whether you want to attend it offline, whether you want to attend it online. So hearing will be done. During hearing, again, you will convince him about your product. You will try to convince him about your product. If hearing is done, then he will ask you to submit the hearing response. You will submit the hearing response, and then he will either grant or reject the patent. Now, what I want to say here, once you file the examination report at the 5th stage, when you file the examination request for examination, after that, after the 5th step, your patent may get granted or may get some examination report, but it cannot directly get rejected. Not a single patent officer can reject your patent just after the examination. No, they are always giving you FER, they are always giving you hearing before they are going to reject. But just after the examination, there might be grant of your patent. There might be grant of your patent just after the 5th stage. So the bracket, green color bracket, what I have shown, it is not compulsory. Most of time, you're getting responses from the examiner, you're getting hearing from the response from the exam, but it is not compulsory. Your patent may directly get grant just after the request for examination and after the examination. You may not receive any examination report from the officer, and it can directly get grant. It can directly get accepted. Then last stage is coming to the maintaining the patent. Maintaining the patent. So what they're talking here, maintaining the patent means whether your patent is get granted now, whether your patent is working or not. Working means what? Whether you are producing any product of it or not. You need to show a maintaining of patent, which is a standard form 27 you need to fill. And through this form, you are going to give a proof that yes, my patent is working. Now, patent working is in different form. Either you are manufacturing it or you have given licenses of your patent to others so that they can produce and they can sell it. So you need to show it that yes, I have licensed it. I have given license to the some investors, some industry people. They are producing it. They are giving it to the public. They are selling it to the public. So you need to show the maintaining of patent to show them, yes, my patent is working. So these are certain steps one should understand, out of which the first bracket, red color bracket I have shown, it is a compulsory bracket. The down one is not compulsory, but yes, most of time you are getting responses, you are getting hearings, and then you are getting grant or rejection, right? Is it clear to everybody how the patent process is flowing? Is it clear? Yes?
Yes, sir. Yes, sir. It's clear. Please go ahead.
Yeah. Now, moving ahead, now there are certain things we need to understand. Let me not go in much detail here. Let me just give you certain things which one should understand while filing the patent. There are certain do's and don'ts in the patent drafting, right? So mostly what happens is, say patent agent is requesting you for some information that you please explain what is your patent is. You just take this small example here. So while making a draft or while explaining your patent to the patent agent, because that patent agent will going to file a patent on your behalf. So when you are going to give a patent disclosure to the patent agent, that time, please focus on explaining the functionality of your product, right? Please focus on explaining the functionality of your product. Now, what it means, say that there is a slicer here in the image you can see. Now, if you're going to tell them it is creating a slices very beautifully, it dices, okay, these are all things are okay, great, not an issue. But how exactly it is going to do that? That functionality you need to explain, whether you have used a proper cutter, whether you have used any coating on the razor, XYZ, or there are different knobs to give you different shapes of the vegetables, likewise. So all these things you need to explain its technicality rather than explaining how beautiful this product is. No. Please focus on the functionality of your product. Right? Next is being too specific. Sometimes it becomes difficult for the examiner to understand. Right? So you should be specific while explaining your things in the patent disclosure, but should not be too specific so that examiner will need to play the treasure hunt, that how can I find this information? How can I understood this information? No, he should able to get a very crispy and perfect information through which he can understand the patent, the functionality of the patent, how does it work, how the mechanism flows, that he should understand. Another do's and don'ts you need to follow, you should not, don't use the non-specific words like etc. It gives you a different forms to that patent. So you're asking that reader to use his or her imagination and fill up the gaps you left by using the words etc. or like this. Don't use this. You be specific, and if you have created a slice cutter, you need to tell them it is helpful to cut the ladyfinger to tomatoes to potatoes. That's it. But you don't tell them it is used to cut the different types of fruits, etc. Don't use that. You need to be very specific for what purpose you have made it. If you want to say that it is useful for all fruits, any type of fruits, mention that, all types of fruits. But don't use tomato, potato, etc. No, not allowed. You are confusing the examiner. And if examiner get confused, then of course you will going to receive the examination report. So while patenting or while disclosing your patent to the patent agent or to the examiner directly, if you are filing your patent on your own, that time you should do or you should use a clear language. You should define the terms, be specific, but not too specific. Be precise in explaining your terms. Describe all the aspects of invention. Include certain example, you may include with some references. Provide the enough information for reproduction. Clearly you state the problem and how the invention is going to solve that problem. So usually the inventions are developed by seeing the existing problem in the market. So explain what problem market is facing or what problem you are facing. And then you explain them how your invention will going to resolve the existing problem. So that you need to tell them. If you have any drawings, please use those drawings. Refer to those drawings in the description. Each and every component of your drawing must be explained in the description of the patent draft. Now, what you should not do. Don't focus only on the specific features. Focus on all the features and explain it. Do not make unsupported statements. For example, you may going to tell them that the device is giving 78% efficiency. But on the other hand, you haven't calculated that 78% efficiency. You are simply giving unsupported statement. Don't do that. Don't even say that this device is having a better efficiency compared to all the devices available in the market. No, again, not acceptable. You will get examination report. So always try to give a statement for which you have a proof, for which you have a supported document with you. Because examiner will going to ask you for any kind of proof whenever he wants. So that is a tact of writing the patent. We are calling it as a patent drafting, right? Which comes with the experiential learning. When you are drafting many patents, then you're getting expert of it, and then you can file those patent with the minimum number of examination reports. Don't disclose too much, because again, you need to be very conscious from the competitor's point of view. If you're going to disclose in complete way, see what I'm trying to tell you, please don't be too specific, and don't try to disclose everything. Means don't disclose too much, so that anybody can make that product very easily, like you have made. No, you need to be only too specific, not too much and not too specific, right? So that needs to be understood. So this is just a tactic one should do, right? So this is how we need to disclose it. Now, don't rush the process. Take your time. And if possible, you may take professional help to file your patents, so that you will get a better clarity and you will get right protection on your patents. Claims writing is an art in the patent, and claim is a heart of your patent. So if claims are drafted wrongly, then you may going to lose many things in the future, which you wanted to protect, but somehow you couldn't. So that will going to, though you have protected the patent, but you have not protected all the required things in your patent. So that can be claimed through the claim of your drafting. So claim is a heart of your patent. So one should understand it, how to protect it, right? And those things must get protected in a proper way. I think I should open for the question now. Thank you very much for your patience listening. I'm open for the question answer session. Am I audible? Hello?
Yes, sir.
Yeah. Yes, please. I'm open for the question now. If anybody has any doubts, please go ahead. Yes, please. Any doubts?
Sir, actually, I have a question. How the industrial patent or copyrights are different from the academics? Academics, especially the management, because management do not have much practical as the technical field have it. We have more theoretical. So how it has been different?
Yeah, see, when we're talking about the industrial design, or when we are talking about the copyrights, these both entities are different, which we have just understood. So industrial designs are for any product or for any specific things, drawings or shape you are going to protect. Copyrights are the work which you have developed, say certain processes, that you can copyright it. You have adopted certain strategies to do certain tasks, that you can copyright it. So whether it is industry or whether it is academics, it won't matter. It won't matter at all. The rules are same for industry. The rules are same for academics as well. Right? There is no difference specifically for industry and specifically for academics. Only one difference is, that difference is in the fees. So when you are filing it, say through academics, now Government of India has given academics, they have considered the academics in the natural person category. So their fees are equal that one individual inventor needs to pay. That much fees only academics organization needs to pay. However, industries needs to pay literally 4 times fee compared to the academics. Only government fees I'm talking about, 4 times. So that makes a difference. Otherwise, there is no differences in the rules. They don't differentiate it whether it is academics or whether it is industry. When your patent is going to any examiner, when your patent is going to any examiner for examination, they don't know whether it is from academics or whether it is from industry. No, and they don't even care for that. If it has novelty, if it has functionality, they grant it. That's it. So that is simple, means there is no difference at all.
Thank you, sir. Okay, sir. Thank you.
Any other question, please? I hope my topic is clear to everyone. One thing I wanted to clear. Now, when we are filing patent, two things are there in the patent. One is the applicant and another one is the inventor. Two things are there while filing the patent. Applicant is the owner of patent. Applicant is the owner of patent. And inventor is just an inventor. He is not owner of the patent. So that confusion, that misconcept is there among many people that inventors are also the owner of patent. No. Whoever, while filing the application, we are always asking the person who is sending us the invention disclosure form. We are also asking them who will be applicant and who will be inventor. Because applicant has all rights to sell, to withdraw, to abandon, to anything to do with the patent. But inventor has no rights. Right? So that needs to be understood. Two different entities, applicant and inventor. It is there in industrial design as well. It is there in copyright as well. It is there in patents as well. Right? So applicant is the owner of the patent. Right? So don't get confused while filing the application and don't be a victim of any wrong thing. Right? So that thing I wanted to make you aware about. Any question, please? I would be happy to answer. Yes, please. I think Dr. Yogita, there is no question from the student side. Should we stop?
Yeah. So, dear participants, if you have any question, you can definitely ask. I think, sir, your session is too much given too much explanation to them that
Yeah.
they didn't have any questions. So we come to the conclusion of the session.
Yes,
so
ma'am.
let me proceed with the vote of thanks with your permission.
Sure, ma'am.
Okay. So good morning all. As we concluded today's enlightening session on the basics of intellectual property rights and its importance for innovators and entrepreneurs. It is my privilege to extend a heartfelt vote of thanks to all those who contributed to making this event a resounding success. First and foremost, I would like to express our sincere gratitude to our esteemed speaker, Dr. Swapnil sir, whose expertise and insights into the realm of intellectual property rights have truly enriched our understanding. Your ability to break down a complex concept into a digestible information has not only clarified the fundamentals of intellectual property rights, but also highlighted their critical role in fostering innovation and entrepreneurship. Thank you for your engaging presentation and for sharing your valuable experience with us. I would also like to thank our organizing committee for their hard work and dedication in putting these events together. Your meticulous planning and attention to detail ensured that everything ran smoothly and allowing us to focus on the vital discussion surrounding intellectual property right. A special thanks goes to SCDL for their support, which made this event possible. Your commitment to promoting knowledge and innovation in our community is commendable. To our audience, obviously, thank you for your participation and enthusiasm. Your presence and engagement have made this event interactive and meaningful. We hope you found the discussion valuable, that you will take the knowledge gained today to enhance your own venture and innovation. Finally, let us remember that intellectual property rights are not just a legal concept, but they are essential tool for creators and entrepreneurs. As we move forward, let us embrace these principles to protect our ideas, foster creativity, and contribute to a vibrant ecosystem of innovation. Thank you